Good afternoon, everybody. Thank you for joining the webinar. Hopefully you'll find by the end of this hour you'll have some understanding or some further understanding of the issues that are going to surround Stage 3. For those of you that don't know me, my name is Craig Budsworth. I'm a partner at Glazier's Solicitors and I've been a maths trainer for the last 7 years. First of all, can I thank you for those who have sent questions in anticipation of the webinar. Hopefully you'll find that by the conclusion of the webinar we've either dealt with them within the presentation or I will come back and have a look at those questions specifically. You'll see as part of the login details that you do have an area when you can type any questions. So if you do feel as though I've missed something or you want to raise something, then please type it there, and if I don't get a chance to deal with it during the webinar, I will do some answers afterwards that we'll email out to everybody. As you'll know, maths training always tries to be interactive. Hopefully you'll find that this is an interactive training session, and during the webinar we will be asking some questions. As I say all the time when we come to maths training, it's in a training room, so it doesn't matter at all what answers you give. Nobody else will see your answers. Okay, so this webinar hopefully will fill you in on all to do with Court Proceedings Pack. So we're going to look at exactly what you're putting together when you're submitting your Court Proceedings Pack. We're going to look at all aspects of Stage 2 within relation to the Court Proceedings Pack and how it's all put together and submitted to the court. We are also going to look at RTA Protocol Offers. So the rules refer to offers that are made as RTA Protocol Offers. So we're going to have a look at what they are, or what impact they have on your claim, and how you can deal with them. One of the other things we're going to look at is defendants not paying Stage 2 costs. So the impact this has, particularly in relation to how you can then potentially get the claim out of the protocol and back into Part 7 and thus getting more costs. Then, and perhaps most people are dealing with this aspect, how you deal with child claims. I've particularly had experience of a number of claims now that are going to Stage 3, and on a percentage basis the majority are child claims. So we're going to take a look at what impact that has, how you deal with them, what slight differences there are. Then a constant question that's put to me: should it be paper or should it be an oral hearing? So we're going to go through the pros and cons on whether or not when you're submitting your payment pack we should be asking for a paper hearing or an oral hearing. And then lastly, and perhaps the aspect that will take up most of our time, which part of the CPR do you issue under? I can hear you all screaming at me now, you're a daft sod, Craig. It's Part 8. But we'll look at twists on how we can get it out of Part 8. So here's the interactive bit, the first bit. What we're going to do is when I ask you a question, it will come up on the screen to give you what I'm going to now be doing. So you'll see that you've now got two options, a yes or no, and we're going to just start off simply. How many of you have taken a claim to Stage 3? So make sure you've got enough time to give an answer. I'll give you another 10 seconds. At this point, I'll be doing the countdown music. Fortunately, I'll stick with presenting seminars rather than sound effects. So, the answer: 67% of you joining us today have taken a case to Stage 3, and 33% of you still have to run one. So first of all, thank you for voting. Hopefully you found that useful and interactive. And if you're in a boardroom looking at this with more than one of you, hopefully now one of you can sit back down. So, the Court Proceedings Pack, Part A. What is this? How does it impact us? Most of you will be familiar with the court proceedings part A, because apart from this bit on the front, the majority of it is exceedingly similar to your stage 2 settlement pack. You'll see on there that the initial bits are dragged through. For those of you using A2A, hopefully your A2A provider has been able to drag them through into the court pack A. For those not on the A2A for this element, because I know there are some with A2A providers who have not been able to link up the further parts beyond the submission of the CNF. So you'll see that on the court pack A, you're going to submit this to the defendant. Now, when do you submit it? One of the questions that's been put to me prior to today is issues on submitting it. So you'll be aware that you've got 15 working days from disclosure of the medical reports for the defendant's insurer to make you an offer. Don't forget these are working days, because I had this issue just yesterday where I thought the defendant hadn't responded to an offer that I'd made, and of course it was Christmas. And so I made the offer on the 23rd of December, and that didn't expire until today. That bit's straightforward. However, what happens if they make an offer, say yesterday, after the 15th or on the 15th working day, and don't forget this doesn't start until the day after you actually submit the stage 2 settlement pack. Your 15 days doesn't run until that day after, so in effect 16 days from the day you submit it. So what happens if they make you a counter offer? If their counter offer is rubbish, do you have to respond? Or can you merely send them the court proceedings part A? Okay, the rules on this are a little bit flowery, and I think when you look at the rules on the whole aspect of stage 3, you'll see that it's a little bit flowery. However, on this bit, the rules say that you've got another 20. So what happens if you don't want to negotiate? What happens if you think your claim is worth £2.5 grand, you've submitted your settlement pack saying £2.5 grand, and the other side have put it through Colossus and they won't go above 2? Can you now issue straight away? The rules don't say yes and they don't say no. This particular aspect that you're looking for on the rules, I think, is 7.38 of the pre-action protocol. I'll come back to you on the exact part, but you need to be considering the overriding objective. Remember, these rules were put in place to stop cases going to court. The idea is that we are supposed to negotiate with defendants. Now, we can't stop that negotiation. So if you submit your court pack A on, say, day 16 because they've made you an offer at £2 grand and they ain't increasing, or sorry, it appears as though they're not increasing, and you don't want to come below your £2 grand, and you just submit this court pack A, potentially you could be penalised in costs. If they don't respond within 5 days of your court pack A, then that means they are automatically saying they agree to your court pack A. So if you're within this 20-day period, say you've reached this day 16 where they've made you a counter offer that's not accepted, you can't just send them this court pack A. You can respond on their system, through the portal, to say £2,000 is not accepted and you're sticking at your 2.5, but to issue prior to this end of the 20 days, the 35-day total period would potentially be being impacted on costs. So what do I mean about being impacted on costs? Simply that you could get to a court hearing on stage 3, having not agreed any element at any point during that case, and the court could say your conduct has been unreasonable. And if your conduct has been unreasonable, the court has the authority to turn around and penalise you in costs, likely to be merely you paying the defendant's stage 3 costs. So in effect, the £250 or £500. Okay, hopefully that's helped and answered that question. So who do you issue against? Which is another question that's come up and one that I've heard before. Okay, you issue against the defendant. That's what's made out in the rules. Okay, there is nothing different here on Part A as to whether or not you're issuing against the defendant or the defendant's insurer. Because remember, if this is on outside of the protocol, dealt with under Part 7, then you're in a position where you could still issue against the insurer under the European Community's brackets, rights against insurer regulations, close brackets, I think it's 2003, commonly referred to as ICRARE. Okay, you need to check your pleadings on ICRARE, but essentially, if you're outside of the protocol, be careful, because if you issue under ICRARE and you've not got the insurer confirming that they are going to provide indemnity, then ICRARE potentially is irrelevant and you could be again penalised and a claim could be struck out. But under the protocol, the insurer is accepting liability, therefore they're accepting indemnity, and thus you can issue against the insurer under ICRARE. Now then, the other alternative for this is when you submit your court pack A, when you do this, the defendant, when they respond, if they respond, which we touched on earlier on the 5 days to respond, in accordance with 7.59, they're actually supposed to potentially nominate. So here you could be issuing against the insurer, the nominated solicitors for the defendant or the defendant's insurer. Under 8.5 of the practice direction, this is where the insurer can turn around and say, once issued, they are the address for service. So don't get the two confused. When you issue in, it's different for when they're accepting service. So they can accept service once it's been issued under 8.5, and then all stage 3 elements are dealt with the insurer direct, but pre-issue on your N1, you are sending it to the defendant or the defendant insurer under ICRARE or the nominated solicitor. Hopefully that's clarified that element. Let me just touch on this 5 days to respond. So following the conclusion of the 35 days, and there is one other element on this which I'll just touch on, sorry to go off track. When you are at the conclusion of the 35 days, if the insurer makes an offer on day 34, there's another 5 days before you can send the court pack for consideration of further negotiations. It's a pain in the backside, but be careful on it. So once you've reached the conclusion of the negotiations, you send this court pack A. They don't have to respond. If they don't respond, it's taken as agreed, which is obviously fantastic news, because that means you can just crack on. So the evidence that needs to be submitted can't be anything further than what's submitted at stage 2. You can't introduce new evidence. If you're introducing new evidence at this stage, then essentially you're making a new offer. So that again lengthens this 35 days, which another element on this, don't forget the 35 days can be extended by mutual agreement. So the evidence. I think for those of you again that know me, you know I love credit hire. Credit hire is my passion. In relation to that element, when you're submitting a payment pack on stage 2, particularly now following the Bent decision, if you have evidence to support the the higher element, i.e. from spot rate checker, showing the amount claimed is reasonable, you can submit that report from spot rate checker and include it within its element or within your evidence. Now, from my experience, I would be suggesting to you that the defendant is not going to supply any counter evidence during stage 2, which means can they introduce it at stage 3? I'll park that one and we'll come back to it. Okay, So on the evidence there, this might be a way of getting credit higher into your evidence on stage 2, which you can help in recovering that at stage 3. Sorry, I've missed one element in relation to the 35 days negotiation. If at the conclusion of the 35 days you are ready to issue, but you are aware of vehicle-related damages, and this is all down to Mike who's thrown this question at me, do we need to extend the 35 days? Okay, Mike, you're dead right. We need to extend it by a further 35 days. Sorry, further 15 days. So on top of the 35, if you've not included the vehicle-related damages, and for those of you who just need a poke on this, the vehicle-related damages are dealt with in the pre-action protocol, and they're dealt with and identified at 4 of the pre-action protocol. And this is specifically the vehicle-related damages is the total loss, the vehicle repair, the pre-accident damage of the vehicle, or the insurance excess. Just a peculiar point on this, the total loss doesn't include storage and recovery. So you could say that that's not a vehicle-related damage, and you could potentially request that as an interim payment. And just a technical interesting point there. Sorry, the vehicle losses is at 1.16 of the protocol. Sorry, not 4. Okay, so yes, if the vehicle-related losses were not included with the original damages, these are now additional damages, and there is a further 15 days to negotiate. So you've now got to this point where you've got this in as your evidence, you've completed all these negotiations, and we're now ready to issue on this Court Pack A, which brings us to what else do you need? And that's Court Pack B. So, Court Pack B, you'll see on this is the bit that's going to go to the court in a sealed envelope. So we're going to talk in a minute about what you include in your M1 and your court payment pack or court proceedings pack. You'll see here on the bottom left-hand corner the claimant final offer, and on the bottom right-hand corner the defendant final offer. I've heard a judge, and one of the judges that was involved in writing the actual rules on this, he was involved in a committee, saying he's been very surprised when he gets the Court Pack B that the claimant's final offer is no different from that contained on Court Pack A. And quite often the defendant's final offer is very similar too, if not the same. In my mind, why is that a big surprise? We're supposed to negotiate, we're supposed to be reasonable, and so it's no surprise that our final offers were already contained within our Stage 2 settlement packs, and certainly within a court, the final court pack. So nothing too complicated about Part B. We'll come back and touch on it very shortly after this, but I want to take you to our next question. So back to the interactive point. Told you we was going to talk about RTA protocol offers. What is an RTA protocol offer? So you'll see you've got 4 options. Is it a Part 36 offer? Is it a Stage 2 settlement offer? Is it a pre-medical offer? Or is it a post-issue offer? So again, I'm going to give you 10 seconds to decide. Hopefully, again, if you're in a room, somebody jump up and press a button now. Here we go with the countdown bit. Diddle-doo, diddle-doo-doo-doo. Oh, there's still a few more voting coming in just late there. I'll just give you a chance. Fantastic. Thank you. So, the results are 73% of you think it's the Stage 2 settlement offer. Okay, thank you. I understand exactly why you think that. The other 27%, doesn't help if I can count, feel as though it's a Part 36 offer. It's the minority that's correct. Fortunately, we're not on Who Wants to Be a Millionaire when we ask the audience on that point. Yeah, it's a Part 36 offer. Okay, so where is it? An RTA protocol offer must be set out in the court proceedings pack. It's there, the claimant final offer. sorry, Court Proceedings Pack B, it's there. The claimant final offer, that is your Part 36 offer. For all the rest of your negotiations under Stage 3, that's the bit that you're going to be relying upon when you get to court. It's always been a bit of an enigma, that bit. What implications does that final offer have? Well, here's where we go back and look at Part 36. You're looking almost at the implications. implications. This is where it decides what costs you're going to get. Because if you go to the final hearing on Stage 3 and you don't beat the defendant's final offer, then there are implications. And just to keep you going on the interactive point on this one, I've got another question for you. So, what are the cost consequences following a judgment where the claimant is awarded less or equal to the amount of the defendant's RTA protocol offer? So remember, the RTA protocol offer is equivalent to their Part 36 offer. So I'll just give you that question again. What are the cost consequences following a judgment where the claimant is awarded less or equal to the amount of the defendant's RTA protocol offer? Is it A, the court will order the defendant to pay fixed costs in Rule 4532? Is it that there will be no order as to costs? Is it the court will order the claimant to pay fixed costs in Rule 4538? Or is it that costs are to be assessed? So if you could all vote now, hopefully whoever jumped up for the last one can have another go. So just another couple of seconds on that one. Give you me Carol Vorderman bit. Do-do-do, do-do-do-do-do. Okay. And the result of our poll is that 92% of you think that the court will award the claimant to pay the fixed costs in Rule 4538. Fantastic. That's spot on. Almost identical, or it is identical to your cost implications on not beating a defendant's Part 36 offer on a Part 7 case. Yeah, you're going to be responsible for all the costs incurred. So hopefully you'll feel more comfortable now in knowing exactly what the defendant or what risks you're running, so that you can make sure your client is advised properly on the Court Pack B offer. Now then, one of the other things, or one of the other questions that has come up is what happens if, after you've submitted your Court Proceedings Pack A, within the 5 days that we've said they've got to agree your Court Proceedings Pack A, what happens? What happens if they come back during that 5-day period and they now agree your offer? Well, you'll be pleased to know that the Behavioural Committee has looked at this very point. They've said, and sometimes I hate reading from slides, it makes me look as though I'm daft and that you lot can't read, but just in case you need to know it, if an offer has not been accepted, then by definition the matter has moved into Stage 3. Report this abuse to the Behaviour Committee. Now this was a bit of a shock to me because in the rules it suggests that Stage 3 does not start until proceedings have been commenced. And this was one of those grey areas that the Rules Committee had obviously not anticipated. How far a defendant can push a claimant, calling their bluff before we get to the point where they're going to agree an offer. So technically they should now be paying your Stage 3. Perhaps technically is the wrong approach here. In accordance with the Behaviour Committee, they should be paying your Stage 3 costs. For those of you that need reminding, Stage 3 costs are £250 on a paper hearing and £500 on an oral hearing, plus your CFA markup, depending on whether or not it actually gets to the final hearing. So, why am I saying maybe not technical? There's a massive issue here on what teeth the behavioural committee have. Okay, I know that some of you have been submitting to defendants insurers saying you are abusing the process. You have made this offer now, or you've agreed our offer within the final 5 days and after the court proceedings pack A has been released. We know as claimant solicitors the behaviour committee have released a report saying that if you do this, you are breaching the spirit of what the RTA protocol is all about. But unfortunately, the behaviour committee, with having no teeth, can't make an order that the defendants still have to pay you. So what do you do? What's the next step when the defendants insurers have effectively taken the mickey? For those of you that know me, you'll know that I've just managed to avoid swearing as this is going to be recorded. So one up. Thank you. So back to the question. What do we do? Here is a big question on how far do you trust your cost draftsman? Have you got an advocate that can take this in front of a judge and say to a judge, we should be awarded these stage 3 costs? This has got to be under a Part 8 proceedings. There's an agreement to pay some costs. It's just that the amount in dispute on costs has not been paid. So, with that in mind, you're dealing with this on a Part 8. It's going to be in hearing in front of a judge, and you're going to have to take this letter from the Behaviour Committee in. Now, this letter that Behaviour Committee, or this report that Behaviour Committee have submitted, is available through MAS. So if you can't find it on the website, then do contact us at MAS, at head office, and we'll be able to send you this through. Don't forget, you also need to report it to the Behaviour Committee yourself. That's why I've put the exclamation mark on the bottom of this. Okay, so if you're stuck in that situation, that's your next step. Pass it to a costs expert, get a costs expert to get Part 8 proceedings sorted and issued with the report from the Behaviour Committee, and in the meantime also report this particular case to the to the Behaviour Committee as well. Hopefully that helps. I think that was one of Alison's questions. So, practically speaking, what do we have to include when we issue? Okay, so you'll see I've managed to give you the practice direction specifically quoting what we need to do or what you need to include when you're issuing. For those of you with case management systems, hopefully you've got your case management system sorted so that this is bringing it up automatically when you're in that position ready to issue. This is what you need to include. Let's give you a moment to read that. So, straightforward. It's not that dissimilar from what you're doing on your M1 forms now or N208 forms, as this will be under Part 8. Very similar to what you're doing on your child claims when you're issuing outside of the portal. Straightforward on the court proceedings pack. Don't forget, Part B has to be in a sealed envelope. If you don't put it in a sealed envelope, you're going to get battered by the judge. Exactly the same as when you're issuing under Part 7 now. The court cannot be aware of offers, certainly Part 36 offers, and this is exactly the same when you're bringing this in relation to your Stage 3 issuing. Now don't forget, you're going to include your evidence. Okay, your evidence has to be attached to this so that the judge has it in front of him ready for the hearing. And again, don't forget, we're going to talk about whether or not it should be paper or oral in a few more minutes. So, what happens then when you've sent your court proceedings pack to the court? Well, of course, they're going to issue it as normal. You're going to get your notice of issue back. And the defendant still has to file an acknowledgement of service. Now, here's a technicality on this. I don't think defendants are filing their acknowledgement of service. You'll see what they've got to do when they're filing their acknowledgement of service. So there at 8.2, this is on the practice direction, by the way, with the acknowledgement of service, any notice of funding. So if the defendant's solicitors are on a CFA, then don't forget that has potential implications when we talk about the RTA protocol offers not being beaten. And the certificate, an acknowledgement of service, or as soon as possible thereafter, the certificate that is in force. Straightforward, the certificate we're talking about is your certificate of benefits, your CRU. They need to make sure that they have obtained a CRU certificate and that it is up to date, and if it's not up to date, they have to get it as quick as. Now then, this is the interesting bit on 8.3. The acknowledgement of service must state whether the defendant contests the amount of damages claimed, contests the making of an order for damages, disputes the court's jurisdiction, objects to the use of the Stage 3 procedure, or, and finally, whether or not it should be a paper or oral hearing. So skip the last bit because we'll be the ones dictating that after I've gone through the pros and cons with you. And let's just look at that bit at 8.31. So the defendant has to state on his acknowledgement of service that he contests the amount of damages claimed, or contests whether or not there should be an order for damages. Court's jurisdiction you're not going to see a lot of, and objecting to the use of Stage 3 I doubt we're going to see a lot of either. But you just need to be aware that when you're seeing that acknowledgement of service, make sure it complies, because if it doesn't comply, you could make an application to strike out the acknowledgement of service and just enter judgment. And the judgment that should be just entered then should be the judgment, or you can certainly request in front of the judge, that the defendant has no right to a representation, and therefore the judge shouldn't read any of the evidence on behalf of the defendant. Hopefully that's helped. Okay, some of the other points that's been coming across is whether or not the defendant has not paid Stage 2 costs. What do you do? Okay, two bits on this. What I'll do first of all is cover whether or not the defendant has paid your Stage 2 costs as quick as they should have done, which is the easy bit, and you've still agreed everything else within Stage 2. And we'll also discuss whether or not the defendant has paid your Stage 2 costs under Stage 3. So the first bit, said to you, that's easy. So if the defendant has not paid your Stage 3 costs, then what you need to be doing is issuing under Part 8. So remember, the rules are saying that the figures should be paid within 10 working days of the conclusion of the negotiation period. Now, this is a bit of an iffy one. Is that the conclusion of your agreement at Stage 2? So say you agree at day 25, should it be paid within 10 days of that? Or is it that on the conclusion of your 35 days negotiation? Okay, this is another bit that's a bit awkward. Technically, the rules are stating that they do not have to pay you the agreed damages and the costs when it's all agreed within Stage 2 until the conclusion of the 35 days. So technically, if they make you an offer the day one and you accept it day one, they could actually hold on to their money for another 9 weeks. I doubt it. Most insurers are not like that. But technically, the rules provide that it doesn't have to be paid for that period, except when there's additional damages. So if you remember, the additional damages was the vehicle-related damages that Mike reminded us of. And the rules on that are that it has to be paid within 10 days of the agreement. So there's a bit of conflicting elements there. So on vehicle-related damages, i.e. additional damages, an additional 10 days is when it should be paid. But when there's no additional damages, you've got a situation where you might not be paid for 9 weeks. Okay, back to Stage 3. So if you are issuing under Stage 3, the rules state that within 15 days of the court proceedings pack, Part A and Part B, being served on the defendant, then the defendant should pay what is agreed together with your Stage 2 costs and Stage 1 costs if they're outstanding, together with any agreed disbursement. And if they're not agreed on the disbursements, then the element that they accept. So, what happens if they don't pay? If they don't pay, you issue under Part 7. Now, again, this is the confusing bit for a lot of people. You had the 5 days to agree following disclosure of the Part A and Part B pack before you could issue, but you're then on Part 7 if they don't issue. Sorry, you're then on Part 7 if they don't pay you. So, can you move it from Part 8 to Part 7 if you issue after the 5 days but before the 15 days? Okay, you could do, but as I understand it, judges are not being sympathetic to this. So be careful. If I was you, I would wait until your conclusion of your 15 working days from disclosure of your court pack A to ensure that that amount is paid. And if it's not paid, then you have to give them notice in writing that as they have not paid, you're now issuing Part 7 proceedings. This is very, very similar to them not paying you Stage 1 costs. Don't forget, if they don't pay your Stage 1 costs within the 10 working days, you have to write to them within 10 working days telling them that they've not paid and therefore it comes out. Okay? Don't forget, if you forget to write to them, then that's why I said before any outstanding Stage 1 costs. In which case you need to, if you're a supervisor, go and grab your fee earner and give them a kick up the backside for not getting it out earlier. And if you're a fee earner, pay attention so you don't get a kick up the backside and get it out. Okay, hopefully that's helped on what to do with costs on Stage 2 and Stage 3. So, the next bit, kiddie claims. Okay, I hate calling them claims for minors because I always think they have to run around with a hat with a light on, but that's just me personally. So, child claims. Don't forget, costs are not paid at Stage 1. Stupid. You'll have all seen, hopefully, that the portal company are putting together amendments to the portal, and as Stage 2 rolls out of the portal, which I think is scheduled for this summer, this is one of the anomalies that I think is going to be removed. Because it's daft. You have to say you've got something to move it on to Stage 2 when actually you've not got it. One of the other bits on kiddie claims is you're effectively not entitled to interim payments. This can be swayed slightly if it's in relation to treatment costs, and you can try and request them if it's treatment costs, but otherwise kiddie claims are not entitled to interim payments on damages. Sorry, I jumped ahead there. Here's my slide telling you about that on the treatment provider. Hopefully you'll agree settlement on Stage 2, particularly in relation to the kids, but if not, then you can take it to Stage 3 where you argue the amount anyway. If you do agree at Stage 2, then 6.1 of the practice direction is where you are filling in the documents that needed to be added to your N208, your claim form, when you're making this. You'll see that in the additional costs on this with child claims is that you are entitled to £150 for the advice on the amount of damages where the claimant is a child, if that's been provided by a barrister. Again, a funny point, as a solicitor or even as a legally qualified person according to the rules, you could make the advice to the court in relation to whether or not the amount agreed is acceptable. However, if you're the solicitor or the legal representative, you're not necessarily entitled to the £150. So perversely, it might be worth passing it to a barrister to do anyway to ensure that you can get this money. Now, one of the questions that's been put in relation to child claims is whether or not the child has to attend the hearing. Now then, in relation to whether or not the child has to attend the hearing, the situation is that if you have a statement, you are supposed to have a statement from the parent confirming that the child has fully recovered. And this statement is supposed to be used by the court to assess whether or not the child will have to attend. Now, again, the rules on this are contained within the practice direction, and it's 6.5.3. Now, what I'm finding with the court is, irrespective of whether or not you have that statement confirming that the child has recovered, the court are still ordering the child and the litigation friend to attend and provide the date of birth. So you need to make sure that A, you've got that statement when you're issuing. Don't forget you've got to include the advice in relation to how much the claim is worth, and be prepared that the claimant will have to attend with their litigation friend, although, as I say, in the rules, the court could say, no, you don't need to come. Now then, I said to you we were going to talk about paper or oral hearings. So here's my next question. I've let you off with questions for a little while. Those of you who've gone to stage 2, and maybe even if you haven't gone to stage 3, have a think. Which would you prefer, paper or oral? So again, I'll give you a few seconds to make your decision on this. People who have gone to stage 3, did you choose a paper or an oral hearing? Here we go with the Carol Vorderman bit. Do-do-do, do-do-do-do-do. Thank you very much. 92% of you have gone for an oral hearing as opposed to a paper hearing. I'm really pleased to hear that, because that's exactly what I'm going to be telling you should be doing. However, there are some pros and cons on this. So let's first of all look at a paper hearing. You can see there from the slide, there are some pros for doing a paper hearing, and really it comes down to whether or not you think you've put a good offer in your court pack B. Okay? If you've no doubt in your mind that you're going to beat their offer, then don't worry about the cost bit, because there's going to be no impact. You will not have to pay their costs. If you beat their offer, you're not paying them. And especially if you beat your own offer and make a really good offer, then you're laughing all the way to the bank. Okay? One of the other elements is you can almost file it with the court, send your N208. Obviously, you need to read your allocation, your acknowledgement of service, which I mentioned earlier. But other than that, your fee earners can sit there on the backside, swiddling the thumbs, waiting for the court to do everything, and you don't need to worry about it, which is superb. Quite happy with that. That means you're doing no briefs, no instructions, no preparing for hearings if you're going to do it yourself. And of course, if you're going to do it yourself, there's no waiting around in court. We like it. Downside, if you win, you don't get as much in costs. Simple as that. You go to an oral hearing, don't forget, it's £500 plus your success fee. So if your success fee is potentially 100%, that's another grand that you're looking at. Not, of course, that we're all money driven, but it does tend to help. Okay, let's now look at an oral hearing. Dead hard. The pros are almost the reverse of the cons on the last one. More costs if you win. Okay, but I think far more importantly to me is the bottom one. I think this is a much, much better service to your client. If you're there in front of the judge, having a good old chinwag with him, telling him exactly why you think the claim is worth X amount of pounds, then the judge is going to be thinking, he's used to this. You know, he's used to seeing people in front of him telling him how much cases are worth. He likes it. He likes being led through the documentation that's in front of him, because then he's not effectively top copy reading to come up with an answer. Now, I would cast dispersion on judges saying they don't read the evidence in front of them on a paper hearing, but it just makes it easier for the judges if you're there taking them through all the evidence that's in front of them. Which of course then ties in with the fact that you're more persuasive if you're there. That's got to be better for clients. Clients have got to like that more. Then the cons, you've got to be involved a bit more. You're earning your grand or your potential grand. Yeah, you've got to be doing this preparation for the hearing. That's irrelevant of whether or not you're running it yourself or you're getting a barrister to do it. Okay, hopefully that's helped so far. Now then, this last bit, CPR. Which bit do we issue under? And I said to you all jokingly, oh, it's part 8. Well, why not part 7? Okay, you have a few get-outs here. Let's talk about, first of all, the days. Don't forget, they've got 15 days following disclosure of the medical evidence to make you an offer. If they don't respond within 15 days to making that offer, part 7 it. Don't hang around, get it sorted. There's no need to wait any longer than day 16. They've had that evidence. They've had the opportunity to make you an offer. So don't hang around. The next bit is your non-payment of your agreed damages. Remember, the agreed damages is the defendant's offer and the stage 2 costs and the agreed disbursements. Now, don't forget here, when you get the defendant's offer, when they do pay you within the 15 days, there's a risk. The risk is that you're passing that to the client and you're saying to the client, as part of that risk, here's the money, but because you've instructed me to issue stage 3 and argue for more, if I don't beat them, you've got to repay that money. Which again means you need to really focus on the offers that have been made, whether they're your offers or the defendant's offers, to be certain that you're going to beat them, or certainly the defendant's offer. You don't want to be in a position where you've not given your client the advice that they may have to repay the money. Okay? Now then, taking it out for complicated legal matters. This is 7.67 of the practice direction. In relation to 7.67, a complicated legal issue, a lot of people have said to me, does this mean credit hire? Because it gives an example on 7.67 in relation to vehicle-related damages. So specifically, it says, where the claimant gives notice to the defendant that the claim is unsuitable for this protocol, brackets, for example, because there are complex legal issues of fact or law in relation to vehicle-related damages, close brackets, then the claim will no longer continue under this protocol. So here's the next sentence is the big caveat on this. However, where the court considers that the claimant acted unreasonably in giving such notice, it will award no more than the fixed costs in Rule 4529, essentially your stage 1, 2 and 3 costs. How do we get around this? There's a couple of ways around this. First of all, make sure you have got a complicated legal argument. I always state the blindingly obvious. The second way is to tell the insurer that you have a complicated legal argument and give them a reasonable period of time to respond, saying specifically, this aspect makes this a complicated legal argument. Therefore, in accordance with 7.67, we feel this should come out of the RTA protocol rules. However, if you don't respond within the next, say, 15 working days, then we assume that you agree that this is a complicated legal argument and should come out. It doesn't give you full protection, but it does help. So my next point that people always ask me is, what happens in relation to credit hire specifically? Perhaps more importantly, arguments over impecuniosity, which is the posh word, don't forget, for being skint, and rates, which obviously tie in with impecuniosity. The answer that I give is, effectively, does impecuniosity relate to multi-track? Of course the answer is yes. Does impecuniosity relate to fast track? Of course the answer is yes. Does impecuniosity relate to the small claims track? Now the answer is also yes. And if it relates to the small claims track, then I think you will be getting penalised by judges for taking it out, but if you've asked to take it out of the protocol because of impecuniosity. So be careful. I don't think that's enough to take it out. Now then, I'm just going to deal with some other questions that have been coming through now while we speak, which I appreciate. Thank you very much. And some others that are still out there. Hopefully, I've answered the questions that you've made so far, but if not, then do give me a nudge to say, please, could you answer some more? Oh, sorry, one of the ones I have missed is the recoverability of an RTA premium. Okay, an awful lot are getting hit on this, particularly when it comes to staged premiums. Is an insurance premium recoverable if it A, is unstaged, or B, in the price of the stage is too much? So let me give you an example. An RTA policy is £100. The defendants come back and offer £76 and pay it and say, jog on, if you don't like it, tough. What do? Do you issue? The court's looked at this already. The court's looked at it in two cases. The first, which I'm sure you're all aware of, is Rogers and Merthyr Tydfil. Rogers and Merthyr Tydfil effectively said judges haven't got the time or the knowledge to be looking at how insurance companies stage their premiums. Okay, it's just not on. They can't be doing all the time spent looking at this, so they have to look at it. Does it look right? Okay, so is it right on an RTA protocol case if you know that an insurer would provide a stage premium of say £100, or should they go for the unstaged premium of say £400? Well, the courts looked at it in Phillips and Widdett, and that's spelled W-H-I-D-D-E-T-T. This is specifically about RTA protocol cases, and the court have said we're going to follow Rogers and Merthyr Tydfil. Stop wasting our time. It's recoverable. So, do you issue for 30 quid? Good question. I would, personally. I know a cost draftsman who will take this all the way to a hearing based on that evidence. There was a few stays on this, so they should now all be paid, whilst Phillips and Widdett was waited, which was handed down about 3 months ago now. So yes, go for it on your 30 quid, especially if you got your cost draftsman on a no-win, no-fee agreement. But I don't think you're going to ruin the playing field for everybody else if you do have a go at the insurers. Now then, one of the other aspects, or one of the other questions I've received, is whether or not we need to pay the court or do something else if, after we've issued under stage 3, an agreement is then reached. Okay, so remember, your Part 36 offers were contained in Court Pack B. So it's not really an amended Part 36 offer, which was, until I read the rules, how I envisioned it would be, in which case, of course, you could write to the court and say that a Part 36 offer has been made, and as such, a stay should be instigated until the proceedings are concluded. But if you look at the rules, particularly CPR 4537, that confirms that an application needs to be submitted to the court in accordance with, I think, 4412C. So if you've got a situation where after submitting stage 3, the insurer passes it to a solicitor who sees a little bit more sense, increases the offer, and you want to accept that offer, then you can recoverable disbursement and listed. It's not listed as consent order, but court disbursements are listed as recoverable disbursements, so you've no problem in recovering that. Now then, I've got a situation. Somebody's come to me with an argument. This is the last question. Sorry, I'll repeat the last question. Sorry, do apologise. The last question was whether or not, what we need to do if the defendant makes an increased offer after stage 3 proceedings have been commenced. So if the defendant makes an increased offer after stage 3 proceedings have been commenced, you need to file a consent order with the court to stay proceedings and the cost of that consent order, as well as your stage 3 costs, is recoverable from the other side. Hopefully whoever requested the repeat on the question has got that one. Now then, one of the other points, or another question has come to me. If a claimant asks for $1,500 and the defendant offers $1,300 and the judge awards $1,200, does the claimant have to repay £100 or the whole of the £1,300? So let me just go through that again so I've got it straight in my own mind. If a claimant puts in their pack A £1,500 and the defendant offers £1,300 and the judge awards $1,200, then the claimant would have to repay the £100, but don't forget the cost implications where you've not beaten the defendant's offer, comes back to the CPR Part 36, and you now have to pay the costs in relation to this, i.e. the Stage 3 costs. Hopefully that's helped. Okay, we are now nearing the conclusion of our webinar. We have still got questions coming through. I'll try to deal with them, but that's making me a little and ahhing, so I do apologise. Let me take another question. If a client does not tell a solicitor initially, but later, after physical evidence submitted, that she has psychological evidence, what do we do? Okay. You can submit your medical report and the defendant can make you an offer based on the medical evidence that you've submitted. That's what the rules provide for. If you've submitted that medical report, you should have your client's instructions on what you have agreed to offer the defendant. If the defendant comes back and agrees the claimant's offer, then you're snookered. You should have clarified this before you disclosed your medical evidence and made them an offer. If, however, you've submitted your evidence and asked for an interim payment while you wait the prognosis conclusion, then fantastic. You then don't have to make them an offer. You could get £1,000 as an interim payment whilst you're waiting the conclusion of the prognosis. Don't forget, if you have a definitive prognosis, you cannot adopt this approach. You have to make sure that your medical expert is saying to you that he anticipates that the claimant should have recovered, but that he might still have an outstanding injury. Sorry, I'm just checking this. This is on part 7, this is on the practice direction, the pre-action protocol on this, and it's part 7 of that, and I'm just doing 7.7 onwards, and I can't remember exactly which part it is. But yes, you need the medical expert. There we go, 7.9. The claimant must send to the defendant the interim settlement pack and the initial medical report containing the recommendation that a subsequent medical report is required in order to request the interim payment. Now, you can get around this if all your medical reports say, I anticipate I anticipate the claimant will take, say, a further 4 months to recover, but that said, I do think that if the claimant hasn't recovered, then a subsequent medical report would be required. So if your medical evidence is saying that, then you could get around it and then submit that further psychological report, and at the same time you've still got money for your client. But remember, practically speaking, this needs to be, when you disclose your medical report to your client, you're getting that confirmation from them as to how they want to progress the claim. And you should be saying to your client at that stage, if you have any other injuries that are not covered in the medical report, then please tell me immediately, otherwise this would compromise your claim. Again, it all comes back to that advice that you're giving the client. Okay, one last minute. So, let you know, I will try and respond to any other questions by way of email, so please come back. And all I can say is thank you very much for attending today. This has been our first webinar. Hopefully you've not realised that, because it's been so fantastic. And if you have enjoyed today's webinar, you know that my passion is credit hire. We've got one issue on this final slide. I've said the 23rd of February and I can't do it, so it will be a slightly separate day. But we've got 2 credit hire seminars running on the 9th of February and the 23rd of February. We'd love you to join us for them webinars, and hopefully I'll enlighten you on some other aspects of credit hire. But once again, thank you very much for your time. Hope you found it useful, and hopefully you can implement some of them points.